welcome everybody. Thank you for coming and here tonight. There's a lot of very familiar faces. I don't think I need to do much tonight by way of introducing Don and Suzelle. They're old friends of the college. And this fixture has become as much a part of the second week of June as sunshine and Pimm's. No, even more of a fixture of the second week of June. There are some things you can rely on, there are some things you can't. And you can't rely on the weather, but you can rely on Don and Suzelle. And they come from California. They don't bring the sunlight with them, but they come, and there's always going to be an interesting hour before we move on and drink and eat. Those of you who were here last year will remember that there was a slight break with tradition, which was that Don and Suzelle decided to talk about one of their own cases, and it was a completely gripping case, and was so successful they've come back with another of their gripping cases, and this is about a fascinating case about intellectual property and identity, and it's about Olivia de Havilland, and who better to tee the evening up than their daughter, Chantal, Gisèle Chulack. I knew I was going to trip up on that. I got the Gisèle and the Galante, and then she suddenly confused me by Chulack as well. But Gisèle is going to, who's Olivia de Havilland's daughter, is going to tee up the evening and put the mise en scène, and then Don and Suzelle will talk about the case. Then we're going to drink, and then some of us are going to eat as well. But Gisèle.
Well, in 2016, my husband Andy and I attended a Howarth and Smith annual Oxford Law lecture. And it's my great honor and pleasure to stand before you this evening and introduce Suzelle and Don. Suzelle and Don have known my mother, Olivia de Havilland, or Dame O, as she's very proud to now be called, for over 25 years. Andy and I first met them on the occasion of my mother's 90th birthday in Los Angeles, and have been friends ever since. Every year, Suzelle and Don make a visit to Paris, and they always come by to visit my mother. On such occasions, they have what Suzelle calls the 3 C's: champagne, canapés, and conversation. For many years, my mother and I have been captivated by Suzelle and Don's stories of the fascinating cases they have handled during their careers, such as the one where they defended dozens of herds of dairy cows. These cows were exposed to stray electricity from a local power plant in Utah. Another case was the Doris Duke estate, the subject of last year's lecture, where Suzelle and Don prosecuted a murderous butler. 2 years ago, in Paris, over the traditional bottled champagne with my mother, Suzelle asked her if she had seen a docudrama called Feud. Specifically, Suzelle asked, "Were you asked to collaborate on Feud? Did you give your permission for Fox to use your name? And did you actually say those things your characters say in the series?" And my mother answered, "No, no, and no." Thus began the long journey through the American courts and the fight against one of the most influential industries in the world, the Hollywood entertainment industry. My mother never shies away when she believes a wrong must be challenged. Suzelle and Don were the perfect lawyers to represent my mother. They're smart, they're tough, and they're perseverant. My mother wishes she was here tonight and urged me to tell you, Suzelle is a great lawyer and a good friend. I could not have asked for someone better to take up my case. My mother, Andy, and I thank you, Suzelle and Don, for your tireless efforts defending my mother's legacy. I give you, Suzelle Smith and Don Howarth, counsel in Olivia de Havilland versus FX Studios.
Well, in a way, I think we could stop right there. Gisèle was so eloquent and so beautiful in her introduction. Dawn and I are thrilled to be here tonight for the annual Howarth and Smith lecture. We are thrilled that you came, notwithstanding torrential rains and monsoons and whatever competition there is going on in Oxford tonight. But we're delighted to be here, and we're so pleased that Gisèle and Andy could also be here with us. And Olivia is here in spirit, if not in body, and wishes us all well. The way we're going to do this tonight is I'm going to give an introduction of Olivia de Havilland because there are many young people in this room. There are many not so young people in this room, many old friends. And I know many of you know who the Hollywood legend Olivia de Havilland is. But for the youth, I'm going to give you some background, and it's important for understanding the case that you understand Olivia's professional and her personal persona. So I'm going to introduce Olivia, and then Dawn is going to discuss the sort of legal nuts and bolts of the case, give you the law framework, and then in true barrister style, I'm going to wrap it up and tell you the evidence that we had that fit on the skeleton bones of the law, so you can see how we put the case together and how it was prosecuted. Olivia de Havilland was one of the great Hollywood stars of the golden era. She was much known for starring in Robin Hood with Errol Flynn, and many men of Dawn's generation fell in love with her as Maid Marian in Robin Hood. She's perhaps best known in America for her portrayal of Melanie Wilkes in Gone with the Wind. She was one of the 4 stars. She's the only living member of the cast of Gone with the Wind, and it was an absolutely brilliant performance. So I know it's a little politically incorrect these days, but it is a part of American history, whether we like it or not, and it's a very beautiful portrayal of the Old South, and the musical score is fantastic, and even though Vivien Leigh won the Academy Award for leading actress, in my opinion, Olivia's portrayal was brilliant, and she should have gotten the award. Olivia has a sister, or had a sister, who's now deceased, another actress, Joan Fontaine. They were both from the Hollywood era, and they have the notoriety of the distinction of being the only sisters in history who both won Academy Awards for Best Actress. Olivia for To Each His Own in 1946, and Joan Fontaine for Suspicion in 1941. As Gisèle said, Olivia was no stranger, has been no stranger to litigation. She was under contract to Warner Brothers, and in fact, she had to get permission from Warner Brothers to play Melanie in Gone with the Wind, which was produced by another studio. The contracts at the time that Joan Fontaine and Olivia were stars were contracts where the studio had exclusive rights to the stars for 7 years. But not only did they have exclusive rights to the stars for 7 years, the studio could suspend you or loan you out, and that added to the length of the contract. So the studios were able to actually manipulate those contracts so that they were essentially perpetual. Well, Olivia wanted to do other movies. She got tired of playing the femme fatales in the Robin Hood type fluff pieces, and she wanted to do more gritty pieces, like the Gone with the Wind role and others. And Warner Brothers wouldn't release her to do the kinds of movies that she wanted to do. They preferred that she have this image of the fainting, beautiful, beautiful heroine. So Olivia took them to court. She was 26, 27 years old, and she challenged the contract system in the courts of Los Angeles, which was a very courageous thing to do. This is a woman of great courage, because she could have been blacklisted, and for a while there was some punishment after she brought the case. But she eventually won the case, and she broke the studio contract system in Hollywood. The Olivia de Havilland law, as it's called, is still being applied today. And the young people in the room, I think, will know who Kanye West is. My son is frowning. I probably said his name wrong. But he, thank you. So apparently he's a rapper, and he's suing his publishing, he's suing his publishing company, and the basis of his suit is the de Havilland law. Olivia made movies in Hollywood for about 10 years after she was freed up from her contract. And then she moved to Paris, where she married Pierre Galante, who was Gisèle's father. Pierre Galante was the editor of Paris Match, and they had a child, and that was Gisèle, who's looking very lovely with her mother, and you can see there, it's a mini-me. Gisèle is a mini-me of Olivia de Havilland. Olivia continued to make movies, and this is important for the case, the understanding that this was a major actress with a career that continued on for decades past the golden years of Hollywood. She also wrote a charming book called Every Frenchman Has One. It is not what you think. But I'm not gonna solve the mystery. I'm not gonna tell you what it is. But for those of you who are going in for dinner, there will be a copy of Olivia's book at your place. And so you can all read this utterly charming book about an American living in Paris and experiencing Paris life. She went on, she was the first woman president of the Cannes Film Festival. She, in fact, there's a debate about this, but either Pierre Galante or Olivia introduced Prince Rainier and Grace Kelly. And over dinner, you can talk to Gisèle about the background of that. In 2003, she's still not forgotten. She's at the 75th Academy Awards event, and when she took the podium to deliver the award that she was there for, there was a 5-minute standing ovation on national primetime television. And all of the actors and actresses and directors just stood and applauded and applauded, and she's a lifetime member of the Academy. As Gisèle mentioned, she became Dame right before her 101st birthday. She's very proud of that, and she calls herself Dame O now. So, in essence, I'm setting the stage for the reputation of a quite outstanding woman. One of the reasons that she left Hollywood to live in France was that she really wasn't part of the Hollywood machine, the gossip machine, the publicity machine, which capitalized on the good and the bad and the ugly involving stars. She was against type of a Hollywood star. She was known for being the lady's prototype of lady, pretty, gentle, and well-mannered. She could also be tough, but Olivia was the consummate lady. The press, however, because the consummate lady may not be that interesting to the public, so the press created a rivalry between Joan Fontaine and Olivia de Havilland, which was really untrue. But this photograph was the genesis of this so-called rivalry. And this is when Olivia won her Academy Award, and you'll see that her sister, Joan Fontaine, is approaching her, and Olivia is looking off in the other direction. You also see there's a man in the picture who's also looking in the other direction. But the press took this and said, de Havilland snubs Fontaine at Oxford, at Academy ceremony. They said that Olivia was jealous of her sister because Joan Fontaine had won the first Academy Award. And so this, on the basis of this photograph, this rivalry of the sisters was created. What's the truth? Does anyone care about the truth anymore? The truth is that there was no rivalry or feud between the sisters, certainly not of Olivia's making. Olivia talked about her sister, and she's quoted in numerous articles, but she said, "I do not look back in anger at Joan, only affection. I loved her so much." Now, she might have looked back in anger because her sister did write a sort of tell-all book called No Bed of Roses, I believe, and it was in some parts not entirely flattering of her older sister. I think Olivia was more beautiful than Joan. I think Olivia had 2 Academy Awards to Joan's 1, and I think the younger sister was envious of her older sister. But from the mouth of Olivia, there was never a harsh word spoken about her sister. Ever the lady, Olivia de Havilland has steadfastly refused to discuss her sister or their relationship since the 1950s. So she never gave as good as she got. If Joan said something snarky about Olivia, she kept her mouth shut. I love this picture of Joan and Olivia, which is courtesy of a friend of mine who's in the audience. Laura Fowler found this, and Laura is a biographer and is fascinated by the golden era of Hollywood. But I love this picture. Don't you love the little ballet shoes that the sisters are wearing? Finally, because this so-called rivalry got much press attention, finally on her 100th birthday, on the anniversary of her 100th birthday, where Olivia was being interviewed by many, many newspapers and magazines, she was pressed and she was pressed. Finally, tell us what you really think about your sister, Joan Fontaine. Well, Joan Fontaine had been dead for 4 years by the time of Olivia's 100th birthday. And so, in true Olivia style, in true sort of well-chosen words, she said, "I have come to describe my sister as the Dragon Lady." The Dragon Lady is someone who perhaps inadvertently has caused some pain to some people who are close to her. And I will say no more. Now, a dragon lady, as those of you who are well-read probably realize, is not an expression, it's not a slur, it's not a derogatory term. A dragon lady is the most powerful and respected creature from Chinese mythology. And Olivia chose it because she and her sister had been born in the Far East in Tokyo. And so the reference to her sister as a powerful Asian woman was meant as much as a compliment as anything else. This becomes important and relevant in our lawsuit. So fast forward to 2017. In 2017, one of the most successful miniseries in American history was aired. It's also aired on the BBC, by the way, for those of you who missed it in the United States. The Feud, Bette and Joan series was principally about Bette Davis and Joan Crawford. Bette Davis and Joan Crawford exploited the press machine with their rivalry, with their backbiting. They used sex, lies, anything that could come to hand to get their names in the public eye and in the press. They planted stories with various Hollywood columnists about each other. Eventually, these two women made a movie when they were together, when they were in their, I'm going to say 50s, which was called Whatever Happened to Baby Jane. And so the premise of Feud was these two women had this rivalry. They made this movie when they were in their 50s. And so Feud explores the relationship between Bette Davis and Joan Crawford. It uses very salty language. There's a lot of sex. In earlier days, it would probably have been X-rated. Both Bette Davis and Joan Crawford were dead, of course, at the time that Feud was made. The theme of Feud was very distinctively about how Hollywood creates a catfight narrative between two women and sells tickets to it. It's about hate as a commodity, a product, a shameful meal placed under a silver dome. So it was portraying women in the absolute lowest way that they could be portrayed. They would do anything to better one another, to get apart, and there were absolutely no rules of decorum or conduct. So, Feud, the series Feud, the writers and producers of Feud, decide that they are going to use the persona of Olivia de Havilland, who they know very well is still living, because Olivia de Havilland knew both Bette Davis and Joan Crawford. And so they write into the storyline the narrator, and Olivia de Havilland, the persona of Olivia de Havilland, is the narrator of Feud. When the series opens, the first thing that you see is Olivia de Havilland sitting down in a fake interview. She's played by Catherine Zeta-Jones, as you can see. Feud spared no expense in doing the costumes, the wardrobes, the settings. They put the characters in places where they had really been. So Olivia, this is at the Academy Awards. She really was at the Academy Awards at this time. She did not, however, give an interview revealing anything intimate about Bette Davis or Joan Crawford or her sister. But the producers and writers of Feud knew that Olivia de Havilland had a reputation for truth and honesty. They wanted the narrator to be someone that the audience would believe. So they open with Olivia, who says in a very nasty way, there was never a rivalry like theirs. For nearly half a century, they hated each other, and we love them for it. Now, one of the reasons that was important to come from the mouth of Olivia de Havilland was she was a close confidant of Bette Davis. They had known each other well. Olivia respected Bette Davis very much. She is the person that Bette Davis would have confided in. So this really was a best friend starting to talk about and reveal personal confidences about a best friend. So this is the man who was the mastermind of Feud. His name is Ryan Murphy, and he's considered to be, by many now, the most powerful man in Hollywood. So in creating Feud, using the Olivia de Havilland character to emphasize the theme of backbiting, backstabbing women in Hollywood, he used the Joan Fontaine and Olivia de Havilland relationship. He has Olivia de Havilland calling her sister Joan Fontaine the bitch sister repeatedly throughout the miniseries. She ridicules her sister to other professionals when they were both young actresses looking for roles at the same time. She reveals her confidences from Bette Davis. She mocks other actors like Frank Sinatra. She and Bette Davis come into the green room at the Oscars, and Olivia looks around and she says, "Oh, we can't get a drink. There's no alcohol in here. Frank must have been in here before we came in," as if he drank all the alcohol in the room. So Ryan Murphy used the Olivia de Havilland character and persona to use vulgar language that she never used, to criticize her sister, which she never did in public, and to put her persona as one of these women who feuds and backbites and backstabs. She was prominently featured, her name and identity, in the advertising and the promotion for Feud. The Olivia de Havilland name and the Catherine Zeta-Jones character were very important parts of the advertising for Feud. Now, there were many, many interviews around the world before Feud came out by the actors, by Ryan Murphy. And Ryan Murphy was interviewed, I've forgotten, Jay Leno or somebody, interviewed and said, we all can see that Catherine Zeta-Jones is playing Olivia de Havilland. So did you talk to her? I mean, Miss de Havilland lives in Paris. She's still alive. And so Ryan Murphy says, "I did not contact Miss de Havilland out of respect." And I thought, that's interesting. You take her name, you defame her, but you don't contact her because you respected her so much. Ryan Murphy also admitted in public interviews that the vulgar language and the actions that are attributed to the de Havilland character never happened, and they were invented to further the storyline. Now, Feud and Ryan Murphy knew how to ask permission. Another Howarth and Smith client, Don Bacardi, who is an artist, and he played a minor role in Feud, just a few minutes on screen in one of the later episodes. He actually did portraits of many of the stars during the Hollywood era. So he did a portrait of Olivia de Havilland, he did Joan Fontaine, and he also did a portrait of Bette Davis. So Feud wanted to have a scene between Bette Davis and Don Bacardi where he's doing the portrait of Bette Davis, and they have a dialogue. So Feud, the producers of Feud, called Don Bacardi and asked if they could use his name and if they could use his portrait of Bette Davis, and he said yes. What they didn't realize was that Don Bacardi is another Howarth and Smith client, and so when I saw Feud, and after talking to Olivia, we called Don Bacardi, and he said, I'll be happy to be a witness. I gave them my permission to use my name and identity. So as Gisèle said, it was summertime of 2017. Don and I went to Paris. We had our usual champagne canapes and conversation with Olivia, and I did ask her those questions. And she said, can we sue? And I said, yes, we can sue. We can always sue. The question is, can we win? And so Don and I did our research. We looked into what are the possible causes of action if your name and your image is taken and used without your permission for the profits of a commercial enterprise, and if false words are put into your mouth, what are the causes of action that you can bring, and what can you do? I will tell you that Dawn's going to tell you about the law, but the research that we did, about half the time the celebrities win, about half the time the studios win. It's very, very much a product of what panel you get in terms of judges, as you will see as we go through this drama. But I'm now going to turn it over to Dawn, and Dawn is going to walk you through the nuts and bolts of the law, and then I'll come back to finish off with the evidence. Thank you.
This time period too deeply into the nuts and bolts, but I do want to give you the two thematic principles in the law that are shot through our law and law in the United Kingdom. And the two that were applicable here were protection of your name. The classic challenge to the protection of your name is a defamation case. The second one that was at issue was the economic control of your name and identity, the right of publicity in the United States. And we'll see it's a little different in England. But the right to control and use and benefit by your name and reputation for commercial purposes. So these are the two thematic principles that we looked at in the US, and we looked at them a little bit for this presentation in this country. Defamation, you're probably very familiar with, quite common publication that's false, not subject to a privilege, and causes damage. So that's a very standard definition of defamation. It's an old theory. It was in Praetorian Edict in 130 AD that you could bring an action for false statements. And those claims, defamation, libel, the written form, slander, the spoken form, false light, a variant that we use in the United States. Well established, the protection of your reputation. This is the academic or theoretical basis for the defamation claim, that when your reputation is hurt by a wrongful statement, it goes to the basic concept of the essential dignity of every human being. A concept that's important to a system of ordered liberty. That's a quote from a 1966 case. So nothing novel about this proposition. In Anglo-Saxon England, slander was punishable by cutting out the tongue. I don't think we pled for that in the de Havilland case as a remedy, but it had long-standing history. It's still very active in this country. This is a recent case, Monroe versus Hopkins, 2017. The war memorial was defaced here with these words. I'm sure that was foul. Foul Tory scum. The incident went viral, and then Katie Hopkins, the right-wing columnist, put a statement on her Twitter over here about Miss Jack Monroe. Scrawled any memorials recently, vandalized the memory of those who fought for your freedom. And the case was brought, liability was found, suggested that Monroe had defaced the memorial, so it was a defamation case. Monroe was awarded £24,000 in damages and $100,000 in fees. I like the proportions there. It's a Howarth and Smith philosophy that there's really no case too small or no fee too large. So it fit well within our premises. It's also been recently, it's not just in England. Here we have Australia brought in this recent verdict, largest defamation verdict in Australian history, suggesting that Mr. Rush acted inappropriately backstage in connection with the production there. And again, Australia brought in a major defamation verdict. So nothing novel in the United States about defamation. Right to publicity is a little more accepted in the United States than it is in the United Kingdom, for example, and I'll show you a couple of examples of that. We didn't make this right up. This is the California Civil Code section. Knowing use of another's name, photo, or likeness in any manner for purposes of advertising or selling. Remember, Ms. de Havilland was used for the promotion of the series or her image or name, or selling goods or services without prior consent. So we didn't make up the notion that you needed to go to her for consent in order to do this, as they did with our client, Don Bacardi, and they did not do with Ms. de Havilland because they respected her so much. The right to publicity has gone up once to the United States Supreme Court in the case that I call it's zucchini, but I sometimes call it zucchini because of the shape of someone being shot out of a cannon. But the great Hugo, the human cannonball, was fired out of a cannon, and a news broadcast put the entire show on the news broadcast, obviously then deterring people from paying to go and see poor Hugo shot out of the cannon. And the Supreme Court of the United States in 1977, on the right to publicity, not defamation here. The rationale for protecting this right to publicity is the straightforward one of preventing unjust enrichment. It's the free rider on someone else's name and reputation. They watch the news show instead of paying to go see him shot out of the cannon. So it was a established right in the United States before our case, this is the only time it's been addressed by the US Supreme Court. There are a number of cases below the Supreme Court. Clint Eastwood features in 2 of them because he's taken considerable efforts to protect his investment in his name and image. And some of the rationale for that you can see in these opinions from California. It takes considerable time and money to develop an image, reputation, person's likeness, and it's used to evoke a particular response, a particular following, if you will. And the First Amendment, which we're going to hear about, that big gorilla wading into the room in a few minutes in the US, doesn't completely abrogate that right to publicity or the right to privacy. Now, in the UK, the opinions say there is no right to publicity, no freestanding right to publicity of the type I just talked about in the US. So in this opinion by Mr. Justice Briss, for someone else who I'd have to appeal to my son to tell me who that is, but Rihanna, says that whatever may be the position elsewhere in the world, and however much celebrities might wish it, there is in England today no such thing as this freestanding right to publicity. Now, the theme, the problem, is still there in England as it is in the rest of the world. And so your courts have come at it in indirect fashions. So in a copyright case involving Lady Gaga, I know who that is, Ames, so you don't need to tell me, they found an infringement of her trademark for an online kids game called Lady Goo Goo. So it was sort of copyright filling that void. But the one I particularly like is the breach of contract theory. This one, Douglas versus Hello Limited, was when Michael Douglas and Catherine Zeta-Jones, who played Olivia de Havilland, had their wedding here in England. They contracted with a magazine to take photos and publish the photos. And other photos were taken and published in a rival magazine. And the court, very interestingly, held that, well, the first magazine that had the contracted for the rights could prevent the second from interfering with their exclusive contractual rights. So they could prevent party number 2, the magazine, could prevent party number 3 from interfering with party number 2's contractual rights that to sign away something which didn't exist in the United Kingdom, right? In other words, what rights were they selling? What rights were they contracting with if there was no right to publicity in the United Kingdom? What were they giving the exclusive to the first magazine for? You have an exclusive right to publish what anybody can publish. But without ever addressing the fact that there was no such underlying right, the court went ahead here and held that they could preclude the publication by the other magazine. So I suggest to you that even here, there is pressure to get to the right to publicity, which you can see in a case like this, and that is the exploitation of their name and image. Now in the United States, we come to the gorilla in the room. Congress shall make no law abridging the freedom of speech of the press, our First Amendment, famous First Amendment. And this was interpreted by a number of leading scholars and jurists in the United States in a very absolute sense. This is Brandeis and Black saying, unless we have complete freedom, whether we like it or not, no views can be secured against the censor. So there was a school of thought, this is in 1957 in the Yates case, that this was an absolute right, never infringe the freedom of speech. What Justice Holmes wrote in the Schenck case, I've never heard anyone give a successful rebuttal to. The most stringent protection of free speech would not protect a man who falsely shouts fire in a crowded theater and causes a panic thereby. Free speech. A law prohibiting this. Do you run afoul of the First Amendment? Well, it's not unique to that example. We have obscenity rulings, we have pornography rulings, perjury, and defamation, all making inroads on this principle. And like so many principles in the law, they move in ether over some period, over some part of the domain, and then they start to conflict with other principles, and you need a reconciliation. And that's certainly been done with our First Amendment. This is the classic case trying to reconcile the First Amendment with defamation. So you go back to 1964, the New York Times publishes an editorial about a racist public official in Alabama. Suzelle's from Alabama, but I don't think she'll be offended by my saying that in 1964, you could put your finger down on a public official in Alabama and find a racist. And so they didn't have trouble finding one. And the Supreme Court enunciated a standard of knowing or reckless falsehood. So the First Amendment, constitutional guarantee, requires proof of the statement. To get around the First Amendment, you had to have proof the statement was made with actual malice, that is, knowledge that it was false or reckless disregard. So we have this surrogate for falsehood that's true in many, many areas of the law. We don't have to prove subjectively that they knew it was false, but either they knew it was false or they should have known. They had a reckless disregard. I'll pick on my son since he called attention to himself. I remember as a young child asking him one time, what do you think is the greatest problem with youth today in America? Do you think it's ignorance or apathy? And his response was, Dad, I don't know and I don't care, right? So we can't get around it by having the subjective requirement that you not know. Even then, even then, with this opinion, classic opinion, you had a concurrence by Black, joined Douglas, who said they would allow it because it should be absolute, unconditional right to publish. So the absolutist school is still there, and Goldberg, in a separate concurrence joined in by Douglas, goes with the absolute view. So the majority did not do the absolute view, but you see it's still there. It's still there in the background. Following that, a number of cases have gone up to the US Supreme Court. This is a Harvard professor, and he was accused in an article of, in the New Yorker. It asserted that he had called himself an intellectual gigolo, whatever that is, and said that he was then the owner of a house that Freud had owned, and they claimed that he said he wanted to make it a place of sex, women, and fun, which I guess means he couldn't make up his mind which. But that was found that it could be defamatory and false, and it reversed a Court of Appeals opinion saying no jury could ever find that to be defamatory. So still there, still a fact test, 1991. In United Kingdom, I think the only difference on defamation, there may be others, but I think the principal difference that I could see and that our very able fellows from this college could see in comparing the two was that the burden of proof shifted a little bit when you came to England from the United States. So in the United States, we would prove that the plaintiff would have to prove the statement was false and caused the injury and the damages. Here it looks to me from the opinions and articles that the plaintiff comes in and shows the injury, shows the statement and the injury, and the defendant, not the plaintiff, has to then prove that the words were true in order to avoid, he doesn't have to prove that it was false. The defense has to come in and prove that they were true. So it's a little difference in burden of proof, but the same substantive law. All right, that's just a quick little walkthrough of the principles that came together in this case, the defamation statements of her character that were put in issue by the things they put into her mouth, like the gigolo professor, and then the right to use publicity. They got the benefit, she got no benefit, she was not consulted, so they free rode, if you will, on her name and image in production of the Feud without a by your leave or a check being sent in the mail. So to tell you then how we then applied this in this case and what the result was, so you can decide to what extent these doctrines are still alive in the US, Suzelle will finish off.
So I want to say a word about the Clint Eastwood cases, because they were significant in our case. Clint Eastwood sued the National Enquirer. One of the cases involved a fake interview, like the fake interview with Olivia de Havilland, where the newspaper reported that Clint Eastwood had a son, his first son, and the entire interview was flattering. There was nothing negative in the interview. It had him saying things like, "This is the most wonderful moment of my life." There was nothing derogatory. And he won that case because he said, the National Enquirer is such a rag that it hurt my reputation for anyone to think that I would be interviewed by the National Enquirer. And so that survived. So with that group of case law behind us, the Eastwood case, the Mason case, the intellectual gigolo, New York Times, and the Zucchini case, we took on building the case for Olivia de Havilland. We had amazing testimony on our side for the defamation cause of action and for the violation of the right of publicity. We had 3 experts from the industry. One, David Ladd, who had been the former president of MGM. He was an actor. He is an actor. He is a writer, very well respected. He was one of our experts that looked at the evidence, looked at what Feud had said, looked at Olivia's reputation, looked at what you would research in order to find out whether something was true or false, and he did a report for us. Court Cassidy, Harvard graduate, well-known, has done many bio biopics, biopictures, biographies, partly factual, partly fictional. He also did a report for us as a writer. He said that he had looked at the Feud production, the Feud script, and there was no way that the words that they used and the statements that they put into Olivia's mouth were done anything other than intentionally. We also had the admissions of the Feud writers that they had, in fact, made up the dialogue and that none of it ever happened. Mark Ressler is a specialist. He's a lawyer, but he also has a company where he represents a number of actors and actresses and their heirs in marketing their names and their likenesses for various purposes, and people make a lot of money in terms of the economic value of a famous name and persona. Dame Olivia herself gave us a declaration that we presented to the court that the statements that were made in Feud were false. Don Bacardi, as I told you, said that they knew how to ask him and that he had given permission. Gisèle gave a declaration that she had known her mother all her life and she had never heard her use the word bitch. And the admissions we had the great admissions from Feud itself as to the falsity. The First Amendment, FX, as Don said, their main defense in this case was the First Amendment protects all speech, even false speech in a docudrama. A docudrama, after all, they said, is partly true and partly false. It's partly fact, it's partly fiction. So how can you have a docudrama if you don't make something up? We will have no more docudramas in the world if Olivia de Havilland wins her case and we're not allowed to have full and free reign over historical figures. In the trial court, when we presented our case and FX presented their case, we won. The trial judge, Holly Kindig, a Yale Law School graduate, she had been a former partner at a major Los Angeles firm, a very well-respected, very erudite judge, a conservative judge, not any sort of liberal, wild judge. And she heard our testimony and their testimony, and she found that we had met the burden of substantial probability of success on the merits by showing that the defendants sought to be consistent with the historical record. They said we tried to make this realistic, and she said this actually makes it worse, not better, because you put Olivia de Havilland into a real world so that the viewing public would think that this is more docu than drama, and that the things she said were the things that the comments attributed to her were the things that were actually said by her. So Judge Kindig held that we had met our burden of proof, and so the next step, when there's a First Amendment case, you always have to get through the gatekeeper, the judge. The next step would have been for us to try our case, and she set an expedited trial based on Olivia's age, and so we had a trial date of November 27th. This was sweet. This was an amazing victory with press coverage all over the world that Olivia Havilland once again had brought the Hollywood entertainment industry to its knees, and that we had the green light to go forward with our trial. Now, Dawn and I, when we first talked to LMH about doing this talk, it was about at this point in the development of the case, and so we were winning. And Dawn and I are doing something tonight that you will almost never see a trial lawyer do. We're going to talk about a case that we ultimately lost. So after the trial court result, FX moved for an interlocutory appeal to our appellate court. There was a First Amendment issue, and so the appellate court took the case. I will not mention any names, but you can look up the opinion if you wish. But the judge, the justice of the appellate court who presided over a 3-judge panel was a woman who had been a partner at the law firm that represented FX in our lawsuit, and she had been the general counsel of Universal Studios before she became a judge. We thought she would recuse herself. She did not, and so I said to Dawn, with an optimistic view, I said, well, it's good. She's going to bend over backwards to be fair, and she's going to find in our favor because Judge Kindig is a well-respected judge, never reversed, and I was wrong, and it did not end in that result. The panel found that the First Amendment, when there's an expressive work, which is any work, arguably, any work could be expressive, but certainly a work that includes a docudrama. It's a combination of fact and fiction, and the analysis takes on a wrinkle. They bought the FX version, the argument completely. Fiction is by definition untrue. It is imagined, made up. Put more starkly, it is false. It is completely protected by the First Amendment. They went on to say that a living legend does not own history, nor does she or he have the right to control, dictate, approve, disapprove, or veto the creator's portrayal of actual people. Now, you might ask the flip side of that, well, does FX, does the entertainment industry, or even newspapers for that matter, do they own history? Can they manipulate history and print falsehoods about real living people? And the panel went even further. They went so far as to say, my Dragon Lady sister has the same effect on the mind of the reader as my bitch sister. So when I argued the appeal, one of the members of the panel said, oh, Ms. Smith, having Olivia de Havilland call her sister a bitch, it's really not such a big deal, is it? I mean, bitch is not it's not a big deal to use that word. And I said, Your Honor, in my house, if my children used the word bitch, their mouths would be washed out with soap, which is true, as my son can say. So I don't know if it's the times we live in. Our judge at the trial court level did not buy the idea that Dragon Lady and bitch were the same or the equivalent, and was actually offended by that idea. But the appellate court says they can say those words. We petitioned the California Supreme Court. As I said, there was much attention about this case from the press, and Olivia, somewhat to my surprise, she has many, many, many beloved fans. And we got lots of letters. There was support all over the world in her favor. There's a vehicle in the California courts that's fairly unusual. In order to file a friend of the court letter or brief in the Supreme Court of California, you don't have to have a lawyer. You can just write a letter to the court, and you can express why you think the case is important. We were trying to get the California Supreme Court to accept the appellate, the case from the appellate court and review it. So we had a record 86 private letters written to the court. I think the most that had ever been written were 17 in some tax case that involved a neighborhood, and everybody in the neighborhood wrote a letter. So we had artists, biographers, screenwriters, newspaper editors, independent filmmakers, bishops, men and women of the cloth, even entertainment industry agents, the Screen Actors Guild, lawyers and fans, and some of you in this room wrote letters in support of our petition. The Supreme Court did not agree to hear it, although one of the justices, Yar, I'm butchering his name, he published his dissent, which is very unusual because on the court, it's very collegiate, and if you have disagreements, you certainly don't have to print your dissent. But he felt so strongly about the issue that he published his dissent. We then tried to take it to the United States Supreme Court, which you can do even from an appellate court in the state level. If there's a First Amendment issue, the United States Supreme Court can take the case. And Olivia was urging us all the time to continue. Let's don't give up the fight. We must persevere. And we had some hope because in this day of the age of the internet and websites and so forth, there's a blog that actually tracks cases where there are petitions pending from the United States Supreme Court. And they had voted us sort of petition of the week. And so we thought, well, maybe the clerks at the Supreme Court will read this and we'll get some interest going. The Supreme Court denied our petition, so we did not get a hearing in the Supreme Court. So it leaves us with the question, Does the First Amendment mean, in the United States at least, that can individuals protect their names at law? Can an Olivia de Havilland protect her name and her legacy? And does it matter? Well, some people have thought it matters. Some courts have thought it mattered. As you know from Proverbs, a good name is to be chosen rather than great riches. And the Supreme Court of the United States in an earlier time said society has a pervasive and strong interest in preventing and redressing attacks upon reputation. Another reason Olivia and Dawn and I thought, and Gisèle and Andy thought this case was important, is that we live in an age of disinformation and fake news. And in a small way, we felt this case was an important one to put the question of falsehood to the courts and to the public. When we got the reversal from the Court of Appeal, we talked to Olivia, and she said, in telling us and asking us to go to the Supreme Court, we must persevere and speak truth to power. The fight is itself important to the principle of honesty, so much in need today in the face of deliberate public confusion for selfish agendas. So she's my hero, she's my mentor. So during all this, during the fight, during the publicity, the inevitable book comes out. So there was a biography, not an authorized biography, but there was a biography about Olivia de Havilland, which was published. And this author was finishing the book at the time that our case was ongoing. He called and said that he would be a witness because in his 10 years of researching the Olivia de Havilland story and everything that had been printed about her, he watched Feud and he was outraged, and he said, everything that I researched is at odds with what Feud put into the mini-drama about Olivia de Havilland. I found almost none of the statements were supported, and he said in his epilogue that the Court of Appeal opinion, which outraged him, does not explain why judges are now casting themselves as film critics. He also interviewed me, and of course, I'm never one to hold back. So I said the Court of Appeal, unlike the trial court, has taken on itself the role of both judge and jury, denying Ms. de Havilland her constitutional rights to defend her reputation, her First Amendment rights to petition for redress against knowing falsehoods. This is entirely a pro-industry opinion, the opinion that came out from our appellate court. Olivia took the high ground during her life. She did not defend herself, refusing to descend into any catfights of the type Feud wanted to and did promote as truth. She's a role model. Can't we have a role model who is actually a lady of culture and morals? Can't we have somebody who doesn't give as good as she got? This is the Olivia that Feud so disgracefully defamed. So what's next? Dawn and I were devastated by the resultant of the final result of this case. And Olivia, with her great feelings for everybody other than herself, said, I know you and Dawn are distressed by the action of the Court of Appeal, but having you defend my name and reputation and getting the truth out to the public was a personal victory and vindication for my legacy. Someone else who is defamed by the industry will, in time, get across the finish line in favor of truth. If that person is smart, she'll hire you. And there are people, which was wonderful. I mean, how can you feel, that raises you up even when you're down at your lowest. But that fight will go on, and there are people, and there will be someone that the industry takes their reputation and drags it through the mud, and it'll be someone with a deep pocket who, like a Clint Eastwood, who will go after the industry for defaming them. And so I don't think this is the last chapter. Dawn and I also are very grateful to the members of the press who published the truth about Olivia de Havilland. So out there in the historical record, even if we weren't able to hold Feud accountable for millions of dollars, we were able to put into the historical record the truth of Olivia, that she didn't say those things about her sister, that she did not betray personal confidences, and that she is, to this day, and remains a woman of honesty and integrity. So thank you all very much for coming, and go and watch all those Olivia de Havilland movies. They're utterly fantastic. Thank you.
So I know that everyone's blood alcohol level is probably dangerously low at this point. So we're going to break in just a few minutes for drinks and then for dinner. But I do want to thank Lara Fowler, who was acknowledged with a picture here from San Francisco, who's sitting in the front row here, and who's working on the next book about Olivia de Havilland and about this case in particular. So she'll be writing, you'll be reading further about it as she's working on that right now. So we're glad to have her with us. Look forward to reading her book when it comes out. Thank you for coming. We could do 5 minutes if anyone's got a burning question or point they'd like to make, or we could just break and do it over drinks. Lord Mance?
Just 2 points, questions. How far was this presented as fiction? Clearly the individuals, not as the real people. Catherine Gisèle, as everyone knows, but it's not presumably, or was it? Because I think at one point you said that they professed to be faithful to reality, and I suppose that's the strength of your case. The other brief point is Don McCarty involvement. I mean, he was protecting his copyright in respect of the picture, wasn't he? So that it may be permission was sought simply because they proposed to use the picture.
So of course we have Lord Mance with astute questions. So the second one first. So there were 2 aspects to the Don McCarty. They asked to use his name, which was separate from the copy of the picture that they put into the movie. So they wanted to use his name and persona, which was, there were two separate parts to it. So if they've gotten permission to just use the picture and they'd shown it, then if they hadn't got permission, it might have been a copyright case. But using his name and image, it invoked the right to privacy, not defamation, because they just had him painting, but it certainly invoked the right to privacy, right to publicity, which is why I think they asked Don McCarty. Now, you might ask me, why they didn't ask Olivia de Havilland. I think the reason is just purely financial. The script was written. They liked the script. They liked the idea of the feuding women. They liked the idea of using Olivia de Havilland's persona because she was alive, and they knew that. And so they didn't want to call Olivia and say, can we use your name and image? And she would have said, well, let me see the script. And then she would have looked at the script, and she would not have approved that script. One other interesting point from Alan Ladd's testimony and Court Cassidy's, the insurance companies will not insure, apparently, a script or a production where you have not gotten the permission of a living person. Never mind the First Amendment, in order to get the production insurance. And so we were not allowed to do discovery. This case was dismissed in an early stage. But we thought that if we could have gotten it, there would have been notes in the file saying, well, what are we going to do about our insurance? Because they had insurance.
So, but before you go to the second point, so it's important to understand that the statute covers living persons, so not people who have passed away. And Bacardi and de Havilland were the only 2 characters in this who were living persons. They got permission from one, not just to use the picture, but to use the name and image, and not from the other. But now on the other point.
So the other one is was it reality? And so, yes, that was important to us, and Judge Kindig understood this. They contrived it to appear that this was real. And that was the point about sparing no expense on the costumes, the jewelry, the hairstyles, everything, the settings that they used. By the way, they also used real replicas of Oscars, And Ryan Murphy was also asked about that because that would have been a copyright case. And he said, well, I didn't ask because I knew they wouldn't let me recreate the images. So, you know, the Academy never sued him for recreating the Oscars. But it was a blatant use of misuse and pushing the edge of the envelope. And it was a gamble that played off for FX in this case.
Okay, one more. Jackie?
Can I just ask whether at the end of the day, the use of the First Amendment was actually a red herring in terms of the argument, because essentially this was really the invasion of privacy of somebody still alive and the use of her name and dissemination of her name for gain, which is really not that much to do with the First Amendment.
Yes, the First Amendment was important here, though, because with the First Amendment defense in the United States, they have the benefit of this early procedure to dismiss the case without letting us get into the discovery period where we'd have a right to get access to their files and to take their deposition. So by invoking the First Amendment, it put the burden back on us to come forward and show that we had a reasonable probability of success on the claims, including that one. There, the judge found we did show that probability of success, only with our own evidence, no cross-examination, never got to get at Ryan Murphy and ask him any questions. Then that went up to the Court of Appeals from there. So there was never any discovery or actual in-court testimony. It was all done by declaration. But without the First Amendment in our country, they would not have had that opportunity, and we would have had a jury trial before we got to that.
What I really meant was it was a little bit of a misuse of the First Amendment because it allowed them to get rid of the case without any hearing on the merits.
Yeah, the people who would argue with you there are not here in the room today, right? All right. Well, we can have more discussion as we go out, but thank you very much for coming. It's been a great pleasure to have you here. I'm not clear where we're going for drinks. Do you know? Where's that? Talbot Hall.
So it's across that way.
Across that way. And by the way, the flowers in front of it are beautiful tonight. I was over there earlier. So Talbot Hall for drinks, and then back here for dinner and for your copy of Every Frenchman Has One.
Thank you all.
Thank you.